Welcome to Life in Real Estate. I'm here with Kristen Wolfram, and Kristen practices family law in Michigan. And in this podcast, we're going to talk about an individual who owns their home. There's no mortgage, it's paid off, and they're getting married. And the difference in situation if you have a prenup versus not having a prenup. Right. So let's talk through that scenario, because a lot of people, let's be real. How many of your clients that you've dealt with had a prenup?
Very few. Very few. And I do tell people, I know that they have a bit of a negative connotation, but I do always tell people who are uncertain whether they would want a prenup or, even sort of certain that they don't want one, that you don't have, you have one, even if you don't have one. And that's under the default laws of Michigan, which is an equitable division, and subject to our particular laws on things like, either custody or property division or whatever the law says. So the prenup is your ability to negotiate what you want as a favorable outcome that you would otherwise be uncertain of under the law, because whether you have one or not, you have one.
Yeah, true. And I don't think anybody thinks of it that way. And I think you're right. I think most people have a very negative connotation, like you're already looking toward the future, that this isn't going to work out. And really spin that to it's going to work out. But in case it doesn't, we both want to be protected, right?
That's right.
And so in this scenario, let's talk about what these differences are and how it can impact you either positively or negatively.
Right. And there's some people who may be better candidates for a prenuptial agreement than others. And in the cases that we're talking about, an individual who owns a decent amount or a decent value amount of property.
So it really depends maybe on how many assets you have or the value of those assets.
Yeah.
It might make more sense for.
That's right. Yeah. I'm certainly not saying every single person who, goes to get married needs one, but if you'd like your assets to be, if you'd like to have more certainty about how you'd like your assets divided.
Yeah.
And if that is a statement that rings true to you because you have assets that might have to get divided, you probably should look into it.
Okay.
Yeah. But in this scenario, we have an individual who has, we just picked this out of the air. So, a person who has a $400,000 property. It really doesn't matter if it's mortgaged or not, but for the purposes of our discussion, we're going to say that it's not mortgaged because I'm bad at math. So we've got a $400,000 property, and this is a person who in both scenarios is contemplating getting married. And in scenario A, there's no prenup. We're just going to leave it to the state of Michigan and its
in case
laws.
Something goes sideways.
Yep. And in scenario B, we're going to have a prenuptial agreement that says that it is our separate property or client's separate property that remains separate after the marriage. So in scenario A, when we have a $400,000 house and you are not, you have no prenuptial agreement, and you just decide to get married, you have converted almost certainly. Now there's some factual determinations, but almost certainly you will convert that marital property of $400,000 into marital property of each, and getting an equitable division of that marital property. Okay. And that is even if the spouse has never contributed a single dime to the house. It's literally just by virtue of becoming married to that person.
So you've just basically split the value of a home that you've already paid for.
That's right.
Okay.
Yeah. And so under scenario A, if we're, again, just trusting it to the laws of the state of Michigan, we get married, we decide to get divorced, we are essentially splitting the $400,000 to two. Under the scenario B, where our client has a prenuptial agreement that says that that house remains their separate property, in a divorce, the spouse is coming in with their own assets, but let's say for the purposes of our discussion, it's zero to your $400,000. So instead of equaling out in the $200,000 range, we're now staying at our $400,000 in our own column, and the other party is left to their own devices of zero.
So you, with the prenup, have the chance of keeping that.
That's right.
For you, and not having to split it with your partner, as well as a potential increase in value of that home if you've been married, say 10 years, and property values have increased. So that counts as well,
Yeah.
the increased value?
Yeah. So in
Okay.
that case, if we keep it as separate property, the prenuptial agreement can either say the other partner is or isn't entitled to 50% of the increase in value.
Oh,
right.
who
So
thinks about that?
yeah,
I mean,
lawyers.
I was going to say, okay,
Yeah.
that's not,
Yeah.
didn't even come to my awareness that that could actually be something that's written into that kind of detail into your prenuptial agreement. But
Yeah.
it makes sense.
Absolutely. So we can lay out that maybe that person, maybe you do think that it's fair for them to be entitled to 50% of the increase in value, right? I should also make clear that the values that we're talking about is that when a person's getting married relatively quickly after the value. The premarital property is premarital,
Okay.
but the increase in value. So if I have this $400,000 home that I received and I own, and then I get married relatively shortly after. Now, if I've had it for 20 years, that is still going to be premarital value.
Okay.
And again, there's going to be an equitable distribution, but you may continue to, have the majority of the value. But without a prenup, that increase is definitely going to be given to the spouse. Whereas our prenuptial agreement can certainly address that, whether or not that's given to the spouse or not.
Okay. So a prenup has a level of protection,
right,
and less risk if things go bad on the back end.
And the length of time, they can always be adjusted. You can always, come back and make adjustments. Let's say, I've decided to put on, a really large addition to my premarital home, right? I had thought that it would be my separate property, but now I think I understand that, I'm going to make this a family home. So we're going to refinance, we're going to take out an equity loan, all these things. But my spouse is going to help contribute during the construction and all these things. So I think it's only fair that they're entitled to an increase. We can address that.
Okay.
But if we don't, right, that again, in our scenario A, where there's no prenuptial agreement, whatever that new increase in value is all going to be marital. There's not going to be a separate property. That's right. That's going to be converted. Yep.
Okay. So let's talk about a scenario where, same scenario, you as the individual, before you got married, own the home, and you do have a prenup, and you're still married, you sell that asset to purchase another home of higher value, say, and you do have the prenup. How does that impact the monetary distribution if you, in this situation, are now getting divorced?
Subsequently get divorced. Yeah. So we look to our document. We see what we planned ahead for, right? Okay. So in that scenario, we might say, and I've done them both ways, we might say that the profit is going to remain premarital no matter what we do with it, right? So under the state of Michigan, under these laws up here where we don't have a prenup, we look to whether or not you've commingled the property and made it marital. And under the majority of circumstances, you've commingled, right?
Right.
Unless you've kept it separate and you've made it clear and the other spouse knew that money was separate and not, you never have access, you never benefited from it, etc. It's almost always going to end up being commingled. Okay. But under a scenario where we have a prenuptial agreement in place, we can say, yes, the increase in value is going to be shared, or it's not. So then I can also say, hey, the profit is going to be shared, or it's not. Okay. So in this case, we sell our $400,000 house, we take all $400,000, and we're going to purchase an $800,000 home. I'm going to keep that $400,000 as my own credit. I can say that when I go, when we purchase the next home. So now that's great. Now we have equal shares because I get the 400 and you get the 400. But if we only purchase a $600,000 home, you're only getting the 2 and I'm keeping the 4.
Right. And so that might, so you're two happy people and you're married, or you're, back up a second, you're doing this prenup.
Sure.
Okay. Before you get married. How is that other person feeling on that side, and what would you recommend for that prenup so that that you want to protect that asset for that person, right? If that's what they really want. How do you try to make it somewhat equitable for for both
Yeah,
parties.
and you really have to. So in order,
otherwise they're not going to sign it.
Well, they're not going to sign it if it's not fair, especially if they have a good attorney.
Exactly.
But that said, there's a lot of things that you can do. So if I'm advising my client who I've written the prenuptial agreement for, there's a couple of ways that at the end of our B scenario, that the other spouse who had less assets coming in can do what's called invade the prenuptial agreement. There's a couple of avenues for that.
Okay.
And
I have no idea what that means.
Well, so that would mean to invalidate it or to say it doesn't apply. So that because for reasons that have happened, so now it's been 10 years since we had that prenup. We don't have that house anymore. I've got 2 kids. I gave up my career to stay home with you. Lots of reasons why I should not.
So a lot of external circumstances. This still will play into this.
That's right. It's not a sure thing. But that being said, there's some things I can advise my premarital, my clients who have a prenuptial agreement, who do some premarital counseling with me. We can advise. So for instance, I can say, make sure we have that joint account, right? Or separate accounts so that, if there is a spouse that ends up staying home, giving up a career opportunity to stay home with children, that we're paying into that. We're saving money in daycare. So we're going to put money in that account. If that spouse then spends it on the or on the marital assets, it spends it on us going out to dinner, that kind of thing, that's fine. We can all use the same money, but we're showing those deposits to show that value. So that at the end of the line, if that spouse says, hey, in a divorce, I should be able to take some of your separate property, I say, no, look, I've compensated you, right? We've compensated you by putting this money in your account and showing that you always knew that I was going to have more assets because that's what I came into it and that's what we agreed.
Okay. All right. This is really good information. Is there anything else you would suggest or advise on this particular subject?
The idea that, probably the biggest thing to advise is that if you do end up having a prenup because you have assets that you want to do, to get it updated, right?
Oh yeah.
It seems like
I've had a lot of people just forget, they've been married 5, 10, 15 years and they probably forgot
and
about that document.
If it's important to you that matter, that it continue to matter throughout the marriage, as long as it's not done in anticipation of a divorce, you can always alter the agreement.
Okay.
There are a lot of rules surrounding whether or not you can make agreements within a marriage. And this is we are continuing to develop that area of law, which would be called post-nuptial agreements. In other words, after you're married, what kind of agreements can you make? Because there's some more.
That might be a really good podcast.
We could do that another time.
Yeah. All right. I really appreciate this. And I hope it's been helpful to all of you. As we continue these series, we'll share more knowledge, build more awareness, and stay tuned. Thank you.